Hey there, I'm estate planning attorney, Paul Rabelais, and in this video, I'm going to describe the various expenses that are associated with settling an estate. So one of the reasons people engage an estate planning attorney like myself is because they've worked their entire life, paid taxes, set aside some assets, and now the last thing they want is that when they die, they don't want a chunk of their estate to go to the government, the IRS, to lawyers, or their state Department of Revenue. So while each estate is different, there are some common estate settlement expense themes that we can address. First, let's look at the tax consequences of dying with assets and attempting to leave those assets to your closest loved ones. Believe it or not, it may not be as bad as you think. While we do have a 40% federal estate tax, it only applies, at least if someone dies during the year 2023, if someone dies with an estate that exceeds $12.92 million in value. And since more than 99% of Americans do not have an estate worth $12.92 million or more, most people don't have to worry about about 40% of their estate going to the federal government when they die. And yes, in 2026, this $12.9 million exclusion amount is scheduled to be cut to about $7 million, depending on some inflation adjustment factors. Note that each spouse in a marriage has their own estate tax exclusion amount. So even if the exemption drops to $7 million in 2026, it really means that married couples will be able to shield $14 million from the 40% federal estate tax. So for about 99% of America, the federal estate tax is not a concern. But then you might be saying, well, that's all right that my estate won't be subject to estate tax when I die, but I don't want my heirs to pay a bunch of income tax when they receive their inheritance. So believe it or not, I think I have some good news for you there as well. You see, an inheritance is not considered income for income tax purposes. If your parent or uncle or spouse or anyone dies and leaves you an inheritance of $1 million, or any amount for that matter, you won't have to pay a dime of income tax. Again, pretty good news there. Now, by far the biggest exception to this rule is if you inherit a traditional IRA or a traditional 401k as opposed to a Roth IRA or a Roth 401k. Whoever gets the distributions from a traditional IRA must pay income tax on the distribution, whether it's the original IRA owner, the IRA owner's spouse after the IRA owner dies, or any other individual who is a beneficiary of an IRA. There's just no getting around the rule that distributions from a traditional IRA are subject to income tax, even if those distributions are from an inherited IRA. So by now you may be saying, well, wait a second. I have a $5 million estate, which consists of real estate, stock, cash, and vehicles. You mean to tell me that my heirs won't have to pay a penny of estate tax and they won't have to pay income tax on the inheritance they receive? What's the catch? Well, I don't know that there is a catch, but let's keep going. Your next thought might be, geez, I bought stock a long time ago for $50,000 and now it's worth $1 million. My heirs are going to get walloped with capital gains tax when I die. Well, not so fast. When you die with assets that have appreciated in value since you acquired them, all of that prior appreciation goes untaxed due to the step up in basis rule. And yes, if you sell that stock that you purchased for $50,000 for $1 million before you die, you'll get slammed with capital gains tax. But if you still own the stock when you die, your heirs will benefit from the step up in basis. If, for example, your stock is worth $1 million on the date you die, then the basis will jump from $50,000 to the $1 million fair market value on the date of your death. That $950,000 of appreciation completely avoids capital gains tax. Another pretty good deal there for your heirs. So for most people, while the tax situation surrounding leaving their estate to their heirs is not so bad, let's look at other expenses associated with settling an estate. I'd say the next estate settlement expense we should discuss is probate. So what is probate and what are probate expenses? So if you die with assets in your name, even if you die with a last will and testament, it's likely that your survivors will have to hire lawyers and go through an attorney and court-involved probate process because your assets will be frozen, and as part of the probate process, judges must sign court orders ordering that assets be transferred to the appropriate heirs based on the terms of your last will and testament. And so what are probate expenses? Well, I'll give you the lawyer answer. It depends. There are likely to be a number of different categories of expenses when it comes to probate. There are attorney's fees, which can be fixed or performed on the lawyer's hourly rate, or it could be based on a percentage of the assets that the deceased person owned. Next, there are court fees, which covers all of the filing fees and various court expenses to obtain certified copies of various court orders that judges sign throughout the process. There are also likely to be either executor fees if the person who died had a last will and testament and appointed an executor, or administrator fees if the person who died with assets in his or her name did not have a will and the court has to appoint an administrator who oversees the settling of the estate. These executor and administrator fees are typically calculated as a percentage of the estate. And then there could also be accounting fees and in some cases appraisal expenses. And to give you some idea of total probate expenses, many people suggest that probate expenses usually tally somewhere in the neighborhood of 3% to 7% of the estate's value, but that's not a hard and fast rule. And if anyone challenges or contests a matter in the probate proceeding, all bets are off because the attorney expenses alone will skyrocket, often to the point of heirs getting nothing. Now, many people, in an effort to reduce or eliminate probate expenses, will create their own revocable living trust and will retitle their probate assets into the name of their trust because assets that are titled in the name of your trust avoid the court and attorney-involved probate process when you die. In your trust, you designate someone as the successor trustee who will have the immediate ability to transfer trust assets to your trust beneficiaries as soon as you pass away outside of lawyer and court involvement, eliminating the expense and delay of probate. Now, yes, there are other expenses associated with settling an estate, some of which include funeral expenses, paying the credit card debts and other debts of the deceased person, costs associated with filing a final income tax return for the deceased person, as well as paying any unpaid outstanding medical expenses of the person who passed away. But the bottom line here is that while each estate settlement is different, many estates are settled with the heirs receiving their inheritance without federal estate tax, income tax, or capital gains tax being due. And yes, there may be some significant probate expenses, but you can take some action during your lifetime to minimize, or in some cases, eliminate the probate expense. And remember, each estate settlement is different with different asset classes, different debts, different probate requirements, different attorney involvement, and the amount of cooperation of the heirs and estate settlement participants can vary with each estate settlement. So with so many variables, the expenses of each estate settlement can and will vary. But I hope that this video gave you some initial insight into the kinds of expenses that are involved in the typical estate settlement. So if you feel you need to get your estate legal affairs in order, you can click the link in the description below and request a no-expense Zoom estate planning design meeting with me, where we'll explore what you want to accomplish from an estate planning perspective and figure out the most efficient way to accomplish it through my national estate planning law firm, America's Estate Planning Lawyers.